Hey everyone, and welcome right into today's explainer. We're diving straight into something that is far more fascinating than just some dry branch of government. We are exploring the Indian judiciary. And honestly, as we'll see today, it's really best understood as a living, evolving guardian of democracy. We're going to map out the structure, look at some of its really unique powers, and trace this incredible journey from a strict interpreter of the law to a completely active champion for the people. To really get why this matters, take a look at these words from Lord Bryce. He said, "There is no better test of excellence of a government than the efficiency of a judicial system." Just think about that for a second. A democracy, with all its massive elections and noisy legislatures, is ultimately only as strong and only as excellent as the courts that protect it. Without an independent judiciary, the whole democratic federal structure just completely falls apart. Okay, let's dive into this. Here is our roadmap for today. First, the integrated judicial system. Second, the Supreme Court at the apex. Third, high courts and writs. And finally, the shift from review to judicial activism. All right, part one, the integrated judicial system. Before we get into the heavy lifting, we really need to understand the basic rules of the game here. Unlike some federal countries out there where state and federal courts are like completely separate parallel universes, India has a single integrated judicial setup. This means the Supreme Court and the state high courts administer both union and state laws together. The whole thing is designed to be fiercely independent from the executive branch. It's the absolute final interpreter of the Constitution. And crucially, it's the impartial umpire whenever there's a clash between the central union government and the states. Moving right along to part two, Supreme Court, the apex. Now, what's really interesting about this slide is how the requirements stack up as you travel to the absolute top. The Supreme Court demands a bit more seasoning, like serving as a high court judge for 5 years, for instance. And because of that, Supreme Court judges retire at 65, compared to 62 for high court judges. It's this beautifully structured tier system where experience naturally funnels all the way upward to the highest court in the land. And speaking of how things are structured, check out these historical monthly salary figures from our source text. You've got 33,000 rupees for the Supreme Court Chief Justice versus 30,000 for the High Court. Now, the actual monetary amount isn't really the main takeaway here. The huge point is that these salaries and all the allowances are charged directly to the Consolidated Fund of India or the state. That means a judge's salary literally cannot be altered to their disadvantage while they're in office unless there's a massive financial emergency. That financial security is a giant shield guaranteeing their independence from political pressure. So what do they actually do with all that independence? Well, the Supreme Court has an incredibly wide jurisdiction. First, you have original jurisdiction, which means it's the very first and only stop for massive disputes between the union and the states. Then there's appellate jurisdiction, making it the final court of appeal for civil and criminal cases. And this is pretty unique. It has advisory jurisdiction. Under Article 143, the President of India can actually go to the Supreme Court and ask for legal advice on issues of high public importance. All right, on to part three, high courts and writs. Now we're shifting focus down to the state level, where the courts interact most actively with everyday rights. Get ready because we're going to do a rapid-fire breakdown of these constitutional tools called writs. But first, check out this super fascinating jurisdictional quirk. The Supreme Court issues writs to enforce fundamental rights under Article 32. But the high courts, under Article 226, they can issue writs for fundamental rights and for any other purpose. That means, during normal, non-emergency times, the high courts actually have a wider writ jurisdiction than the Supreme Court itself. Crazy, right? Okay, so what are these writs? Let's break down the big five. First up is habeas corpus. Translated from Latin, it literally just means have the body. This is your ultimate safeguard for personal liberty. If someone is locked up by an authority without proper legal justification, the court uses this writ to command that the detained person be physically brought before them. And if the detention is illegal, they walk free. Basically, if the police hold you without a valid warrant, this is exactly the tool your lawyer uses to get you out. Next is mandamus, which means we command. Think of this one as the court's legal cattle prod. If a public official, a lower court, or some government authority is just flat out refusing to do their legal duty, the High Court or Supreme Court fires off a mandamus to legally force them to do their job. Then we have certiorari, meaning to be certified. This is essentially a supervisory check. The higher courts use this to protect citizens by quashing the order of a lower court if that lower court stepped way out of its lane or misused its power. It's kind of like a giant undo button pressed by a higher authority when a lower court breaks the rules. Now, you might be wondering, how does that actually differ from our fourth writ prohibition? Well, they're super similar, but the real key is the timing. While certiorari is issued after a lower court has already made a decision, prohibition is issued before the proceedings are even finished. It literally stops an unauthorized legal action dead in its tracks before any damage is done. And wrapping up our rapid-fire writs is quo warranto, which translates to, what is your authority? This one protects public institutions. If someone is wrongfully occupying a public office that they aren't legally entitled to hold, the court uses this writ to say, hey, what's your authority here? And if they can't prove it, the court boots them right out. Let's move to part 4 and see how this builds. Review to judicial activism. This is where things get truly profound. We're pivoting here from mechanical rules to very dynamic powers, starting with judicial review. We are talking about massive power here. This is the court's ability to look at a law passed by the legislature or an action by the executive and just declare it completely invalid if it violates the Constitution. A huge historical example of this from our text is the Keshavananda Bharati case. That's where the Supreme Court established the basic structure theory, essentially ruling that Parliament absolutely cannot alter the fundamental core of the Constitution. But let me ask you this. What happens when the legislature and the executive don't just pass bad laws, but instead they fail to act entirely? What actually happens when the other organs of the state just go completely inactive when it comes to the welfare of the people? The answer? Judicial activism. When the legislative and executive branches drop the ball on their constitutional duties, the judiciary doesn't just sit on the sidelines acting like a passive referee. No, it steps right onto the field. It takes full responsibility as the active guardian of the Constitution, issuing orders to make sure the machinery of government is actually working for the people. And this brilliantly illustrates the real-world impact of that activism. Public interest litigation, or PIL. Traditionally, only an aggrieved person could actually file a case. But with PILs, the court totally democratized justice. Now, any citizen or group can approach the court on behalf of victims who can't do it themselves. The courts have even taken up cases entirely on their own, just from reading newspaper reports. Literally. Through PILs, the judiciary has jumped in to protect child laborers, improve public health, and fight corruption, all without waiting for formal lawsuits to roll in. Which brings us to our final takeaway for this explainer. The Indian judiciary is undeniably this incredibly dynamic force, and it has massive public support for stepping in when the government fails. But, as the source text rightfully points out, this trend also gets some heavy criticism. It brings up a super fascinating debate. When the judiciary actively steps into legislative and executive territory to protect the people, is it just fulfilling its destiny as the ultimate guardian of democracy, or does it risk becoming this unelected super chamber of government? It's an incredibly delicate balance of power, and one that makes studying India's courts absolutely vital. Thanks for exploring this complex system with me today, and keep questioning the structures that shape our world. Catch you next time.